people are looking at what are we going to talk about. I think that is what came up, which is what I understood. Because maybe it's too vague. I mean, I always put out these topics which are just general. So let's bring whatever thoughts we can. But sometimes I think people did not connect. But as the symposium going on, I think there is connections for people which are being made. So of course. So, but Georgina, thank you very much for being part of the symposium, and looking forward to your session. And of course, you'll have to tell us about yourself, and then give me a minute to, because it's a different session. I have to go through the website and just tell people where to find information. So please, Georgina, about yourself.
Thank you very much. It's a great honor to be here, well, virtually, but at this symposium. And when I first came across the connection between philosophy and mediation, for me it was magical, because one of my greatest loves since I was a teenager was philosophy. And I can see, well, not only about what I'm going to talk about today, but I've seen that through the speeches, there are a lot of connections between the two. And philosophy is a cornerstone for many, many things. Well, for me, my training is in law. I'm a solicitor in England and Wales. I've formerly been an academic educating and researching in law for several years in the UK. And over the past 2 years, I decided to make this switch to mediation. And I'm very happy to be between the United Kingdom and Greece as an accredited mediator, looking at both cross-jurisdictional disputes, but also in separate countries. I hope I've covered the basics about my profile and background, but essentially one of the key things I've also been interested in, and that's where I can find a lot of connections with philosophy, is psychology. Looking at mediation through trauma, mediation through responses that have been identified as responses we would have to any kind of trigger. I can see that these do come up in the mediation process. And of course, when I study psychology, I can see the huge connections we can find with things that were said so many thousands of years ago in these philosophical texts across the world, not only obviously in Greece. So I don't know if you'd like me to start with my presentation, or if we should.
Look, the standard format. You have to give me 1 minute to put out information, and then it's your show. Of course, I mean, in Herman's case, we took a little too much time talking about what I was doing, because we were talking about the mediation circle and we didn't have much time there. So that I have to apologize to Herman for, but I'll tell you the reason why I put this up. I have to put this up. Okay, mediatorvikram.com, of course, information. I mean, basic idea of connecting. I mean, I'm like available, very, very accessible in every way. I try to reply as soon as I can, because the time zones, definitely there is a time when I'm not available for replying, but yes. So of course, support part of it, World Mediation Circle, shows and events. And that means, I mean, now there are more than 450 videos. So there is a lot of information, and how to find the links. I've tried to put out links, I mean, through the channel and everything. And there is what Ken's, all the shows that he's been on, that's one separate section with all the YouTube links there. So there are YouTube links of all. We started with evolution of a mediator, and then there's this in conversation with beautiful mind, lots of shows. I mean, let's not take your time on that. The important thing is that please have a look, that all these people from all over the world have given their time, and they've come up and said, I mean, it's been really nice, all the thoughts we've got from all over. World Mediation Circle definitely is my focus area now, to create mediation circles in every school, every community, every organization, and issue based. So let's do it that way. Start small, we'll grow as we go along, because I'm very selective of the people who have to be part of it, because like Andrea says, that you've created a safe space. I really want to keep this a safe space in every way for anyone who's part of it. And Michael Lang says that this is like your living room. I always say that you're in my living room. So whoever I would want in my living room is what, I mean, that's the way I look at the entire thing that I do. So that's about it, Georgina. Now it's your show. And we are here as spectators. You can bring us in if you want to, totally your wish. So philosophy and mediation, why that introduction was because in my World Mediators conference, there was Martha she's also from Netherlands. And we did a session on neurodiversity and mediation. And she says, look, I sometimes see that you just abruptly start a session, but that's the way I do. Let's start. And he says, we don't know what you're talking about. She's autistic. And she was speaking about her, of course, her, I mean, experience in general about mediation also. But that aspect of it that we want to know what you're talking about. So that a little introduction, I started after that. Normally, I would not do that because it takes time. Like we've taken your time on this and we took Herman's time there. Should not do that. So please, Georgina, philosophy and mediation, your show.
Thank you, but it's great to get this introduction to show all the work you're doing and how you're connecting people across the world. I think this is fantastic. So thank you for that. Well, yes, I think because of my Greek origin, I'm also actually part of a philosophy group here in Greece. In the UK, I was part of the Stoic Society in the United Kingdom for a few years before the pandemic kicked in and we couldn't have any more live meetings. So I was a bit in a dilemma as to where I should go with my presentation. But of course, I thought it would be a great idea to look at the tools we use in mediation and see and discover where I've seen these before in my readings. So when we think of a qualified mediator, I think we usually imagine somebody that is very well acquainted with modern negotiation techniques. And usually we think that he or she must be up to date with the latest trends through reading. And I'm going to mention a few books. I think you will be well aware of these. The Getting to Yes, Ask for More, 10 Questions to Negotiate Anything, Getting Past No. And a book I'm always asked if I've read is Never Split the Difference. So this is what people think a mediator would know, would read, should be reading. But conversely, if you told somebody that you're applying a 2,500-year-old approach to your mediation practice, they would probably be somewhat skeptical and maybe think twice before appointing you as a mediator or collaborating with you. But the truth is that little would they know that it is in fact these classical methods of dialectic, which are in fact applied not only in mediation, but in all these therapies now that are called dialectical behavioral therapy, cognitive behavioral therapy, CBT. And of course, in psychoanalysis, we do have a key part, and I think you mentioned silence before, which is very important also in psychoanalysis, but also questions. And if I can reflect on the poem that was shared by Herman, this is essentially what I want to unfold today by talking about Socrates and his method, which is all about the questions. And this is a 2,500-year-old technique and process, which in fact very good mediators do apply in their mediation practice, and they excel. And this helps parties not only experience safety in the mediation process, but also leaves them feeling quite empowered. So the question leaves them feeling quite empowered, and that's very important to remember. So what I'd like to do briefly today is to see why and how this is applied in mediation, how we can make connections to this. So I'll try and see if I can share my screen.
While you're sharing your screen, I'm going to say that now you've got this topic for the next symposium, which is psychology and mediation. That's coming up.
So please count me in. I'll definitely have a lot to say there as well.
And Socrates and mediation, I did one full part of my forum series. We had a very nice discussion on Socrates and mediation, and Federico was part of that. He's coming up later today. Very interesting. He's also a professor, and it's really interesting thoughts there. Yeah. So you can share your screen.
Yeah. Let me see if I can do this correctly. Yep. Have I done? Okay, fantastic. Okay, part of it at least. So the use of the Socratic method in conflict resolution.
Do you want to do a share screen in the sense of, slideshow?
Yes, I should do this on my PowerPoint. Probably.
Yeah, it would be better. I think we'll be able to see the entire thing. Whatever you're comfortable with, it's totally yours. Show.
Yes, no, I'd prefer it if I manage to do it.
Nothing on the slideshow?
Slideshow.
Yeah, slideshow. Play from start. Yeah.
Okay, fantastic. Okay, much better. Essentially, is Socrates' dialectic method forgotten and buried in the studies of ancient Greek civilization? The answer is no, not at all. Dialectic is actually, as I said, the go-to tool. We think it is only for educators, therapists, and coaches, but actually it's one that mediators do use. So as of course you will all be aware, but it doesn't harm us to revisit his background. Socrates was a Greek philosopher from Athens, who is actually credited as the founder of Western philosophy. And the important thing to remember with Socrates is that with his intervention, his existence, there came an anthropological shift in philosophy generally, meaning that after Socrates, man, in fact, became the object of philosophical thought. And so profound were his teachings that essentially that's why we have in ancient Greek philosophy, when we are teaching it, the division between pre-Socratic philosophers that were mainly focused on the understanding of the world, the universe, and post-Socratic philosophers that were actually focused on, as I said, understanding man and have a more anthropological way of discussion. And of course, as you will know, as all great thinkers, leaders, and innovators, in 1399 BC, Socrates was accused of corrupting the youth. And after a trial that lasted a day, he was sentenced to death. And he spent his last day in prison refusing actually to get any help from others to escape, because he wanted to stand by his principles and ways of teaching. And of course, when we look at Plato's works, because that's how we know about Socrates, the Apology, Socrates questioned and cross-examined his fellow citizens not to convey a new truth to them. I think this is very important to remember when we're thinking about the mediator and the mediation process. So not to convey a new truth to them in the manner of an instructor, but only to point out the path along which it might be found. So when we look at Socratic questioning, what we're essentially wanting to do is dig a bit deeper. And this is why we have the different types of questions, which is a toolkit we can use from. And very important that Socrates' dialectic method requires that we have a participation and appearance of equal status among those involved, that the dialogue does start with commonly held views. It aims to lead to critical reflection among the participants, and then we connect these ideas following this process. And essentially what I'd like us to focus on a bit more is the 6 types of questions that we can see in the Socratic questioning, which have to do with those of clarification, those that probe into assumptions, those that probe into reasons and evidence, those that challenge viewpoints and perspectives, those that consider implications and consequences, and also very important and my favorite, which is questions about the question. And I thought, instead of going into more detail on the Socratic questioning, I thought, what best than to have a paradigm and apply it to a case study in mediation to see what kind of questions would Socrates ask, or what kind of questions would we ask if we were trying to integrate this kind of dialectic into our mediation practice. And before doing so, I think it's very important to remember that before asking the questions, there's also a process of active listening. And active listening is quite key for us developing and understanding what questions might help the parties in mediation move forward in their thinking, mostly. And this is why I think it's very important to be mindful of the fact that we need to afford a certain amount of uninterrupted time for the parties to speak. And I think this is where silence, again, comes in as a very, very important part. Active silence, I would say, because we're trying to engage in active listening, in being silent, in maintaining that safe space for the other person to speak. So time, and maybe having a timer to, even in our mind, as to giving the appropriate time for somebody to speak. Listening, so it's not always about looking at someone, but it's also about thinking, how do we actually listen to what they're saying? Are we focusing on the words, on the tone, on the expressions? Are we listening to this, not just experiencing the visual of what is going on in the room? And of course, note-taking, I think that is quite important, because then with note-taking, we can also start thinking about drafting these questions. So the case study I thought it would be useful to bring over has a lot of details which represent things that are and have happened in very recent times, and we've all experienced or heard about in the news. So this refers to a small business manufacturing car company, which comprises of its two founder engineers, and they have been taken to court for breach of contract because they decided and failed to make payment for the equipment and parts they had received from one of its suppliers, from one of their suppliers based in Ukraine. And of course, the Ukraine suppliers did eventually deliver the goods to them, but failed to do so within the time frame they had agreed. And this, as they claim, was because of the government in Ukraine imposing certain restrictions at the start of the war. Emails were exchanged about the transfer of goods, and it was agreed in the emails that they would opt for air transfer instead of sea, but it was not established who would cover these increased costs, these air transfer costs. It was also unclear because there were delays in communication. This delayed the process of the transfer further. It was also unclear whether appropriate notice was actually given about the delays to the small businesses, to the small business regarding that it would be faced with these delays with delivery of the goods. Now, due to these delays on the small businesses side, they, in their turn, did not manage to deliver any of these cars on time. And it is assumed that this is what led them to lose two of their major clients, two companies based in China in regions where the lockdown from the pandemic was still being experienced. So I hope you got there on the slide. I have some main points of this case study. But the key thing here is to try and see, when parties make a claim, how do we apply the dialectic method or these types of questions in our practice, and what is the purpose of this? And I think it is more evident to us, it will be more evident to us when we do look at the statements and what questions we could ask. So the small business would say that we will not pay the amount of monies for the goods because they were delivered to us late. So if we were to make a question of clarification using the Socratic method, we would want to ask, what do you mean when you say late? Could you explain this point further? And this is because we need, those of you who have a background in law will appreciate that we need to understand that certain words are very important because they have been interpreted by judges and they can be reflected in certain clauses in the contract. So we need to get a lot of clarity on things that parties at times discuss and refer to in obscurity. So what is late? And late, according to a party, might not be late according to the other party, and late may also not be late according to the judiciary or the contract or legislation. So questions of clarification, very, very important to be mindful of that for any type of statement made by the parties. Then we need to test assumptions. So party B, for example, could say that it was because of the delay that we lost business from our two major clients based in China. And the question that would probe into this assumption would be, how can you verify or disapprove the assumption that the clients you lost were because or solely because of the delay? Okay, so we need to test these assumptions that parties have made, and at times being in the position of somebody who is in this conflict, who has suffered loss, it is very hard to not think that something that is a statement and an understanding is not an assumption they are making. So it's very important as the mediator to pose these questions which try to at least bring some light into the thinking of this party or any of the parties involved when we ask a question which is probing into an assumption, so that they can see actually that what they think is the truth might actually just be something that they need to delve into a bit deeper. Then, of course, we can have questions that look into reasons and evidence. So, for example, Party B, the issues with the government in Ukraine at the start of the war is what caused us to delay. We had nothing to do with these delays. If we wanted to look at the evidence, we could ask them, what are the restrictions imposed by the government analogous to in the context of business? When and how was the delay communicated to the other party? So we need to get some evidence at times to see if there's accuracy also regarding what is stated, what claims are being made. And of course, viewpoints and perspectives, and I'm going to touch upon this later on, because we do have all these very modern terms that are used. Also in these handbooks I referred to in the very beginning of the talk, which are actually, as I said, in this dialectic and have to do with perspective taking. So Party B says, since they agreed to the suggested transfer of goods by air instead of sea, which happened in the emails, they should be with the ones to cover the increased transfer costs. And if we were going to ask a question to Party B, it would be along the lines of, what is another way to look at this? And could you place yourself in the position of the other party to see how they would assume the reverse? How is your argument and their argument on this point very similar? Which would lead them to see that the other party could make the exact same claim. And of course, implications and consequences. In mediation, we have a very standard phrase that is used, which is a reality check. that parties, usually after the half day of the mediation, will be brought in the face of what the consequences would be if they went to court. What can they practically expect to get as compensation if they went into court? And this has to do all with what would happen in reality, and not what would you like to happen, or what is the ideal answer that you have envisioned as a party is what you will have as a result. So again, questions that look at the implication and consequences are made, and we usually label this as a reality check in mediation. But here, if we made a question to the party, if we pose a question, let's say that their companies, the companies that had their base in China, in regions still in lockdown from the pandemic, were only affected by the delays and canceled with us, is what party A would say. And here we would ask party A, what generalizations can you make in relation to most companies based in China at this time? What are the consequences of the assumption you are making that these companies were unaffected by the current lockdown? So we try and see what implication and consequences the parties haven't thought of that are unrelated to their very limited view of the dispute. And of course, questions about the questions, which I said is my favorite part of the dialectic for both party A and party B here. We could ask, to what extent were you responsible in delays with your position on the change of the way in which the goods would be transferred? And essentially, a very key question which makes a party think is, why do you think I'm asking you this question? And this is how they can see that somebody external is also not very clear or is asking a question because there is not much clarity, and is making them think of the why these questions are being asked. Have they actually asked themselves these questions? So I hope that wasn't too detailed for you, but I did try to take the dialectic and apply it to a real life example of what we would have in a mediation case. And of course, modern day dialectic, and very important to remember that when we're talking about mediation, and I'm very happy that there will be a symposium on psychology and mediation, because I think philosophy and psychology are the cornerstone to engaging in mediation in a more creative and holistic way. You will have come across, when we look at psychology, of the very powerful tool of reframing. And we all know that the brain likes thinking in stories with narratives. And more often than not, we all have a story that's locked in certain positions, and then leads us to have a very narrow view of the way in which things will happen, have happened, are happening. And what reframing does, and this is of course how Socrates' dialectic helps parties through these questions, is to reframe step by step what they think the story is and what it is from somebody else's side, or which elements it might have which they may have not taken into account. And perspective taking also is a very popular way of engaging two parties in seeing the stories from different sides. Reality checks, as I mentioned, and of course, BATNA and VATNA, which is something that is looked at in a lot of depth in these negotiation books, which I have referred to, and many, many more that deal with mediation, which is the case where we look at the best alternative to the negotiated dispute or the worst alternative to the negotiated agreement. So we look at case scenarios of what is the best, and this is where the reality checks come in as well. What is the best case scenario and what is the worst case scenario? And this again takes us to the question that Socrates put forward, which had to do with implications and consequences. And of course, I wanted to make a very strong connection with the different approaches we use in mediation. And of course, the wider public that is not trained in mediation might not even know that there are different approaches that are taken in the mediation process. And even mediators may not deliver mediation services based on one specifically, but they might tailor the way in which they approach a dispute depending on the parties' personalities, depending on the stage of the dispute, the nature of the dispute, and also what aim and objective we have for the closure or the resolution of this dispute. And of course, facilitated mediation is a standard approach. And in this respect, the mediator essentially takes a more hands-off approach, and we would say exchanges information and communicates information between the two parties, trying to have a more, let's say, neutral approach with the goal of just creating this facilitative environment where both parties in the dispute can speak relatively openly and freely. When we go to evaluative mediation, this tends to be a bit more hands-on than facilitative mediation. And the primary focus here is preparing the final agreement between the two parties. And sometimes what the mediator does is essentially that he or she tries to forecast the likely outcome if the matter was decided in a courtroom. And somewhat paradoxically, evaluative mediation can help participants avoid litigation by placing their trust in an agreed upon authority whose opinion can serve as a substitute for a judge, which is that of the mediator. And there are, it has become very popular through the court systems in Australia, in the US, and also in the UK, to have this case appraisal where we are using the mediator's skills, legal skills at times, and legal knowledge and background, but also practical mindset to evaluate the dispute. And of course, when we look at transformative, this type of approach in mediation focuses on reaching resolution by improving the communication of participants. And essentially, it's much harder work, but also quite important if we want the relationship between the two parties to be preserved. So this, I think, with the transformative is where we try and empower the parties and work to equalize unhealthy communication styles or power dynamics. And as I said, it's very useful when we are not only trying to resolve the dispute, but we're also trying to serve the parties by saving and salvaging their relationship. And why are these approaches very important to our discussion of Socratic questioning? Well, because essentially the dialectic and being mindful of the existence of these approaches can help us see how interventionist we need to be as mediators when we are engaging in discussions between the two parties, and to also question ourselves about the approach we are using. And this is why I think the Socratic questioning is not only very important for the questions we ask to the parties, but also the questions we ask to ourselves as mediators when we are trying to think of solutions around these disputes, and whether parties would want us to intervene in a facilitative, evaluative, and transformative way. So these questions are very, very important also for us to be mindful of, to question actually what type of questions we want to ask, and if we can take advantage of a specific range from Socrates' questioning and dialectic, depending on the type of approach we want to adopt in our mediation practice. And as I said, reframing is very important. Usually when it comes from the area of psychology, we look at this cognitive triad, which is how we view ourselves, how we view the world, and how we view the future. And this is also very, very important in the mediation process. And our questions when we are trying to look at how we can reframe, or how we can help parties reframe the situation that they are faced with, is to see which one of these three elements is causing the most tension in the dispute. And of course, as I said, Vatna, again, it has to do with one of the Socratic questions on implications and consequences. This, although it's labeled as part of the negotiation process, I would say that it is definitely very aligned with that of the dialectic. And I guess I did touch upon a little bit about my background, but I wanted to kind of share my credentials here because of the Greek background I have, and I'm very happy that I've been able to take the knowledge and years of experience I've had to, so to speak, to bring parts of this back home. And in this respect, I think it's very, very important because all of us, no matter where we are from, have a certain cultural background that is rich with tools. And it's very important for me to see also this cross-cultural dimension in mediation. And that's why I'm very grateful that I'm part of this symposium where it has managed to connect people and offer a safe space for ideas around the world, because when we're looking at mediation, we need to find tools that also have to do with it's a cultural heritage that has been given to us. And this is why I think philosophy across the board would be something that is very, very embedded in all cultures. And for me, it's very important that I have been given the opportunity to speak about Socrates and questioning, also because it is part of the Greek heritage that I have been following also through studies at school, not only with philosophy, but also with the study of literature and a lot of key pieces that actually we can see in mediation. It's all about narratives and about the way in which conflict and tragedies and drama unfolds. So although I have a background and training in the UK for many years, I'm very happy today that I managed to look at it from also this background I have in Greece, in which I am aiming to establish more ground with mediation. And of course, in my practice, and this is where I want to connect it with why the teaching of Socrates is quite important for me, and it kind of informs not only mediation practice, but also the way in which I think of peace building and solutions, with mediation being the starting point, is that if we want to have parties that feel they are supported, they should be supported at all stages of conflict. And having this dialectic that Socrates has offered us is very important at the different stages that have to do with conflict resolution. So we should not only think of these questions as ones that we can ask when we are providing mediation services, but also when we are asked to evaluate a case. Can we ask key questions which the parties hadn't thought of? Even if we don't mediate in the particular dispute, these questions might bring them closer to discussing certain points. These questions might help them avoid an escalation of different points of their dispute. And then when we're looking at conflict resolution coaching, if we're having a one-to-one in training, which is something I'm a firm believer in and which I want to develop more on a global level, are we teaching people to know to ask the right questions when they want to be empowered in their organization, or as you mentioned, you will aim and have done this so far by making mediation part of different organizations, from schools to universities, to training of mediators in all these platforms. So when we do this, are we giving them a toolkit that can be used across the board? And I think this is where philosophy plays a really key role in us showcasing the importance of mediation, because philosophy has certain principles which almost feel very common because they are centered on the groundbreaking, let's say, innovative approach that Socrates took, which was bringing attention back to the man. Well, man or woman today would be the appropriate, but bringing attention back to us as human beings and these common virtues and issues we all face, which do not meet any kind of distinction or discrimination, but are across the board important to all of us to unfold and discover, because we are all human beings. So this anthropological approach is something which I think should be adopted at all levels that concern a dispute. And this is why I think it's not only about the mediation services, but also everything surrounding peacemaking. So thank you very much for offering this space today. I'd be very happy to discuss any points with you. And if anyone does want to contact me, I have all these platforms, and also active on YouTube and LinkedIn. So thank you very much.
Thank you. That's a lot of stuff. But only thing, let me tell you, Georgina, you've opened out discussion into things which I keep talking about on my shows and events, which I will have to take you through, because more than 450 videos, I don't expect you to watch. Maybe all of them. I don't even know any of them, which you'd get time to watch any of them, but I'll put out the points. But one comment that we had was about the slides, that are you going to share the slides? If you want to share the slides, you can send it to me. I'll send it to them. Totally your wish. Otherwise, the link to the recordings I put down there, the link to the recordings are available in my newsletter.
Yeah, I'm very happy to share them with you, and you can pass them on.
Perfect. So now you opened out discussion on a lot of things. So I'll have to take you through all of them. The first thing is you spoke about books. Now, I've always been saying that I don't read books. So I have a show called Talking Books. So we talk about books. I mean, with Ken Cloke, I told him also, look, I don't read that. Look, for me, I think what is important is that someone sitting somewhere has to look at it from a very different approach, maybe an open approach. I mean, everyone is right in the way they go about it, but I just felt not to be influenced by things. So when you said Getting to Yes, I haven't read that, but of course, you know about that book. But I said, why Getting to Yes? I'm talking about, look, this is my title, don't take it. Getting to Hugs. That's the way I would want mediation to develop. And that's the medieval mediation circle, when I talk about that, I don't know whether you read that, the concept being this. This is, I think, is much beyond getting to yes.
Yes.
So I think
No,
that
I would agree that and this is why we need to make a distinction between negotiation and mediation.
exactly,
Always, because we are not trying to get anyone, or we should not be trying to get anyone to do anything, especially if there's a boundary where they don't want to say yes. So I completely agree that this is why I wanted to flesh out that actually we should be looking further back in time. And I saw the word virtue, I think, in your
ethics, moral
ethics, yes. And I think it brought to mind why philosophy is so important, because it's one of the key points in any philosophical discussion, or in most, is about the virtues. And this is, of course, something that when we look at negotiation techniques, it's not very, very mindful, I think, of this part of philosophy, which is quite important to lead us in the right direction of respecting, I think, discussions and boundaries.
Yeah, because when you see my shows, you will hear heart, soul, spirituality spoken a number of times on that, because I have the kind of mediation I want to promote. Look, there is that other mediation which is going to happen. When you spoke about the court system, and I'm linking it to getting to yes, and I keep saying that the fact that we are putting them under this situation that it'll take you so much time, it'll cost you so much, so you should settle. You've actually got to yes with a gun on their head. That's not the mediation that I would want to promote. I mean, that's why I'm saying that I start at the grassroots level, create that atmosphere, and we go along. Because, like, you used the early neutral evaluation. Now, the neutral word itself, I am debating, which is coming up in the symposium, which starts on the 12th, neutrality and mediation. Because Bernie, of course, has written lots about it. For the last 20 years, he's spoken about neutrality. So let's discuss that, because that's a word which comes out. I mean, it's used so commonly in relation to mediation, but we have to debate it. And if you want to be part of it, please be part of that discussion.
Yes. No, it's very important that you mentioned this, and this is why, again, I think asking questions is much more powerful empowering for the parties, and powerful in terms of getting them to think. Whereas, yes, you're right that when we say early neutral evaluation, it's neutral because I'm not representing, or the mediator is not representing one of the parties, but it's not neutral insofar as, yes, there are some parameters that are taken into account. But I think that's why the dialectic is so beautiful, because essentially, when you ask questions, yes, there can be a bias in the questions you ask, but when you are given this toolkit of so many questions, you're essentially trying to get other parties to think and give you their thought process, not even a solution, but their thought process around something, or it gets them to think if they have the full range of ideas they should have that they're looking into. So I think when we're talking about all these concepts of training people, of mediation services, of early neutral evaluation, we need to think very, very well about the methodology that we apply to it, because that can make the key difference. And this is why I think I wanted to integrate this in the discussion of different techniques, because yes, these are all very useful, but as you said, we are not going to threaten someone that if they don't settle, they will go to court. But they do need to know that if this was to go to court, have they thought, so ask the question, have they thought of the time, energy? So we're not telling them to do something, but we are asking them a question. Have you actually, thought or been taken through other examples? Or have you ever seen your dispute by analogy, how it was dealt with in another case? So I think asking these questions is empowering the parties to actually not twist their arm, but make them think.
Because I'm moving away from the whole concept. Of course, look, the court system, what it's done is the worst that has happened to mediation. It's going worse. In the UK, if you look at the situation, it's gone to the extent of the court saying that you did not negotiate in good faith and gone into costs related in connection. I mean, it's going to get absurd and even more absurd because the foundation is so weak. And you'll hear that, I mean, a number of times if you watch my show. So I'm giving you a gist of it so you know where that thought is coming from, because that is something becomes a major part of whenever mediation is spoken about on that connection. So I mean, I'm not going to leave that. I'm going to leave that to you having a look if you can. But that's the general thought that I have on training. Also, you'll hear me on this. Even that World Mediation Circle, I have spoken about it. No qualifications required, nothing. Why I'm saying so is because I'm going out and saying, let's identify those people who have that skill, and they have it. They're all over. Let's bring them into the fold, because if you bring the right people into the fold, the user experience is good. And if the user experience is good, the process takes off because people talk about it. Today, that whole debate on the user talking about mediation, what is it that they're talking about? Because the elephant in the blind man situation, someone experiences mediation. Today, there was this group of mediators where someone, or the WhatsApp group, someone put out a message that some judge was appointed as a mediator by the court. And the judge in the last 12 sessions and has only asked for pleadings. He doesn't understand where it's going. So that's the discussion that happens today. I mean, after so many years of mediation in the court system in India also being there or everywhere, I mean, it's just going into an absurd direction. So I said, okay, in a way, put a blind eye to that and develop it on a different way, because this blind man in the elephant situation, you will see people have experienced it differently, like you said about the evaluative, transformative, that aspect of it, facilitative. The point being that if someone experiences a certain part and is told this is mediation, for me, you are tying the hands of a mediator by putting it there. But user has no idea. User has no idea about these models. We are the ones who keep confusing the user by telling them mediation can be this, mediation can be that. It's just, what rocket science am I getting into? What am I going to enter into? What are they going to do? Is there something happening here? Is there some whatever voodoo happening here? What is happening here? So I think for me, it's the user, and simplify it for the user. So at least from their perspective, connect them to a process which they are totally familiar with. There was a symposium last year called, I mean, this was August and September last year, which is Mediation in Our Culture and Traditions. So there were 97 speakers from some 45 countries. And the theme of that was this, that the mediation word they might not be familiar with. They're familiar with the process. So let's connect them to the process. And if we connect them to the process, obviously they understand everything about mediation. And that's what I keep doing. I just keep telling people that, okay, this is a process. For me, the definition is so nice and simple. The Singapore Convention gave us that, and I keep pushing that definition everywhere, because it takes away all these words, all the models and everything. Whatever be the name, however the process is conducted, that's immaterial. As long as the third person is assisting you in resolving your disputes and doesn't have the authority to impose a solution, it's so simple. And we go into larger concepts of talking about mediation, and the guy gets totally, I feel that the user is the problem. UK, I mean, look at the UK. In that symposium, we had Andrew Miller, of course, senior mediator there. He said that 18,000 certified accredited mediators in the UK, 500 have work. So what is the system that we are creating? Where is the flaw in it? So I dug deeper. So like you said, the Socratic method of digging deeper. I said, let's dig deeper into mediation in the world. What's really happening in the UK? What's really happening in the US? Because training part of it is the common thing which is discussed. And that's the only place that people are making money in mediation. Mediations are not happening. It's the training. Those people are the ones who make the money. And I'm saying the people are already there who actually have that. We'll talk about skill development. We'll give them. I mean, skill development is one thing and training is another thing. Because if your training is like, I'm putting something in you and I'll make you a mediator in a 40-hour factory. It's like saying, I'll make you a philosopher. That's why I'm connecting philosophy to mediation, that a philosopher to a mediator. You don't create philosophers in 40-hour factories. what Georgina is, and her, like you said, going her background, the Greek connection, and look, it's something that you pick up in your house, in your whatever you community, in your life. These things you pick up as you go along, and be the person you are, the philosopher that you are, the mediator that you are, is based on so much value systems and everything. So to say we'll make you a mediator in 40 hours, I have a big issue with that. I mean, we are demeaning mediators, and mediators are demeaning mediators by saying we are going to make you a mediator in 40 hours and come to us and all that. So
Yes.
those are things you'll hear. I'm putting it in just to you so that, of course, you give your comments on it also. I don't want to miss out on the opportunity, because whenever this comes up in front of me, I have to clarify this, because for me, if I don't clarify it, it's like I have actually not spoken about something that is really close to my heart on this. So now your thoughts on it, I put out the broad parts of it. What are your thoughts on this?
No, I really like your thought process, and you've touched upon a lot of, I will ask a question, or maybe I should ask you a few questions rather than share my thoughts. But so the fact that, let's say 500, and I co-presented with Andrew at a conference at the Institute of Arbitrators on sustainability and mediation. So it's also a very, I think, interesting topic to delve into in our times. And on this point that you said that he shared that from all the mediators that have been trained, 500 are actually doing the work. I'm not quite sure if that's only because there are not enough mediations, or we would need to, the question would be, why does this happen? And also, which are the mediators that have more work? And how, because I can see also that there's a culture in the UK where the success of a mediator is dependent on the rate of their settlements. And yes, this could be reflective of how well a mediator does his job, but it also couldn't be reflective of the fact that a mediator hasn't forced anyone to settle. So that is not reflective how good a mediator he or she is. So this brings us back to kind of the discussion and the questioning. What does the audience know about mediation? And what has been the popular and most used technique when we think of mediation? Is it the kind of mediation that has the more adversarial lawyer type? Or is it the kind of mediation that has more the therapist, philosopher type? And I think there are different types of mediators out there. And I do believe that because mediation now is becoming more widely known, we will have those that develop themselves as practitioners outside the legal profession. Because I think the legal profession is, to some extent, the one that has pushed a certain methodology to be embraced in the mediation process. And this is why I think the work of having a symposium of this kind and connecting people through different themes like philosophy, psychology, shows that mediation actually, yes, it's not about you're going to pay £2,000 and you are going to lose your reputation as a business if you don't sign here. That's not the type of mediation that all mediators want to adopt. And then for me, it is quite important that those using this tool as participants know the variations of mediation, because then they can know how to choose their mediator in the long run. I mean, maybe it's too early for this to take place, but I think as we develop, I would want parties to know if that I will be, for example, a little bit more interventionist because they have told me that they want to save the relationship. Two business partners that have a disagreement, they do not want to just get money and leave. They want their business to continue together. So then you have to apply transformative mediation, or in a prospective divorce, the couple might want still to be together. In other situations, they might just want to have a clear-cut separation. So I think it is quite important for parties to also empower you with the level of intervention that you as a mediator will have, because that's where you can avoid a disappointment. And that's why with the questions, I think the more spot on the question is, the better the experience. And that's why it's important for us as mediators to really ask parties in the beginning to ask themselves certain questions. And through those, we can also see maybe what approach we want to take. Because I'm not saying that, you know, having a philosophical approach or a more transformative approach to mediation is the best. It does depend on what the parties will actually feel comfortable with. But I think the points you've raised are very important, because essentially, yes, there is this type of mediation out there, which is not representative of the way in which some of us want to conduct our mediations. And that's why this platform is very, very useful. To engage with each other, and also for others to listen as to what is out there.
There is a question that May has put. I'll come to that later, because what you've said needs to be, of course, discussed. Because look, finally, what you spoke about lawyers and the connection of mediation with lawyers, and that's the way mediation is being heard. People are hearing about mediation. Oh,
yes.
That's the only way they're going. And what we're doing is we're doing disservice to mediation, because mediation is happening all the time between families and communities. It's all happening there. And we are trying to say, this is what I keep saying about the class distinction and the colonization of mediation, that there you are telling them, these mediators whom you are already there in your families and communities are low class. They're not really mediators. Why do you even go to them? These trained, qualified, certified, accredited mediators are mediators. So a class distinction that we are trying to create between the fact that people whom they use. This is why the colonization, because colonizers said, you are savages. We are going to tell you how to live your life. You have no idea. Same way, these people they have nothing. They don't know about mediation. We will tell you about mediation. And ultimately, it's not about the process for me. It's about the trust in the individual. And whoever they trust, however that person takes it through, they trust. That is what trust is all about. So whether it is facilitative, evaluative, transformative, happening at all the same time, or how it's moving, as long as they trust. It's like saying someone is walking off a cliff and you can see them walking and you're shouting out, I'm facilitative, I'm going to shout out only, and I could not physically going to stop them. And the person is deaf, they can't hear you. And you still let them walk down. I just feel that you're doing disservice to the process and the individuals who trusted you. So, I mean, those are my thoughts about it. I'm not saying that.
I understand your point is that, yes, it is. The word escapes me in English, but in Greece it's litourgima. And there are some professions that are about the person, are about their personality, are about their values. And if I've understood correctly, you're saying that this is far more important than ticking the box of being a mediator according to this and that. But unfortunately, also, this is one of the ways that the world works. So
no, I tell you, we have to create the world, Georgina. We'll create the world.
No, I agree, but it's also one of the ways that that the world works, through processes. But I completely agree that it is about the person and not the title.
No, I'll tell you, this again, you'll hear me, because I'm saying you won't be able to go through all the sessions. I'll tell you about it. I keep making the analogy between a mother and a mediator. Now, tomorrow we are going to say we are going to certify women, only they can be mothers. And the mothers who have been there for you know how many centuries and thousands of years.
Well,
No,
they
those
have
are
discussed this actually. There
yeah,
is discussion around this.
yes, those are not mothers. The ones we will certify, only they can be mothers, because they were, again, we'll go back to the savage concept. They are savage. They have no idea how a child has to be brought up. We are going to, everything is not going to be a process. And we will do disservice to humanity by saying everything is a process. Everything has to, some things are not going to be put into that category. It serves people's purpose. It serves people's purpose, if, be it, say, the judiciary in case of mediation, because they are inefficient. I keep saying that I'm going to tell you all these points because I feel that you will connect to them, and you're going to take it further. You're not someone who's going to say, oh, let him talk, but I've got this idea. You're open to thought. That's why I'm talking to you about it. Talk to you about it. So the judiciary is the most inefficient institution in the world, everywhere. And for them, this is an escape route. The mediation is an escape route for them. So for them, that's the way, that's their vested interest. So for their vested interest, we are falling into the trap. And again, the whole discussion around these mediators in the court system, they're passionate about it. They want to help people, doing it for free or almost free. They're doing that. And that is the way it serves the purpose of the judiciary. On the other end, judiciary, to say that you go for a process and pay market value to these people, people are going to question. No, they're going to question it. Constitutional, you have a constitutional duty to give us the whatever justice we want. You have to do that. And if you send us to another process, under what scheme of things are you doing it? Because we came to you. However, why are you pushing us off there? So if it's free, they won't mind. Okay, not a problem. We'll try the process if they're telling us. But if it's not for free, why should we do it? So they don't want to be, judiciary doesn't want to be questioned there. So this is there again, their escape route, the way they've structured it. And some people just feel happy. They're happy being part of that system, to be recognized by judges. And maybe the judges will make them judges, because that's the way the whole thing works. Judges make judges. So maybe they'll become judges. Some of them are, mediators are in the court system for that. Some will be recognized that maybe we'll get some work from the judge. They'll refer some matters to us. I mean, all that is happening. There's a little coterie of people who are doing what they like. Mediation is happening on such a large scale outside. And in relation to the number of disputes out there, I mean, we have study in India. We are very less. We only put in 18 million matters into courts every year. That's it. That's very small in compared to our population. The US puts 100 million matters into courts, and they're only 300 million population. We are 1.4 billion people. So we're doing something right somewhere. And that is the one that we have to connect to, because I keep giving this example of, I mean, the fact that in India, I don't know, I just told you the population. Out of that, 60% is in rural areas. That 1 billion people are sitting in rural areas. To connect them to something connected with the courts is something we're taking into a direction which doesn't serve their purpose. So that's because
it's also this discussion on access to justice, which I think mediation.
Yes, I talk about that.
Role to play.
This is where I keep talking about, because the judiciary has always tried to create this access to justice and mediation linkage. That's access to justice. I'm saying that is again not justice, when your inefficiency leads to someone having to settle when they knew that they should not settle, because I mean, it's like for one could be the fact that you are, again, the power imbalances. There's a large corporation, huge funds for litigation available to them. Small guy, for whom the fact that there can be costs imposed on them is a fear. So to say that you have gone into a process and you've settled, you've got justice, you're fooling people. Because again, judiciary interprets things. They interpret over their own vested interest, what they do, they interpret that. What justice did the guy get? His case was, he was sure this was what happened. This person had to give me money. They did not give me money. Now he has to pay me money. No, settle for much less than that, because our court system is going to take you through a process which is going to be long, it's going to be expensive. So you settle, and you settled where you did not want to settle, but now you've got justice. They just create this. They'll keep creating
I agree.
absurd things.
But I think I also see mediation as an avenue for people to not abandon their rights as well. So settlement, of course, is not the ideal. But then abandoning one's rights completely, this is where I think access to justice needs to be revisited, and how mediation can come to kind of mitigate the problems that we have with, yes, because court system is also something that only a particular class can take advantage of, if we think of it.
Exactly.
So essentially it leaves all these other people exposed to either nothing or something that they need to be aware of that is either provided for by, so having state-funded mediation would also be an idea for certain cases. I don't know.
I'm telling you, I've spoken about this. The fact that you are saying state-funded, we as taxpayers are going to fund people's disputes now. You go and fight with someone and we will fund that.
We do it already. So
exactly. Why are we falling into that trap over and over again? Because finally it's denial of justice which is happening. Because again, you'll hear me saying this: justice delayed is justice denied. And in the UK, what you're saying is bad. The fact that there is so much delay. Think of what's happening in other parts of the world. Think of India. I mean, 14 years is the average amount of time it takes. I keep saying that in terms of, look, finally, if the judiciary is going to sit there and see what matters, go for mediation and all those things happening there, someone sitting in jail is actually not given justice because you are spending time on something else. And even 1 hour, if you put someone behind bars when they are, what is the concept we keep saying? Innocent up till proven guilty. What is the innocence if you put them behind bars? Was the person guilty? What basis did you put the person inside behind some? I mean, taking the freedom totally, and on the other end, you're sitting and talking about whether this commercial dispute should be going. Even that 1 minute you spend there talking about that commercial dispute going for mediation or anything else that you do there on that discussion, someone sitting in that jail somewhere is suffering because you don't have time. What business do you have? This is a colonizer's mindset. And that's why this whole symposium that I had on colonization, decolonization, and mediation, this is a colonizer mindset that we can do this because we are the judiciary. We are on a pedestal. We are the ones who actually are going to decide what should happen to you. It's going into absurd directions.
And this is quite interesting, like to bring it back a bit to the discussion. I think if you read Plato's, not quite sure in English, where he talks about the structure of the society, and he actually said that philosophers should be the ones that will govern. So I think maybe we need to think the judiciary rather than just not having anyone govern. No, because the judiciary, I think, does have a role in safeguarding the rule of law.
That's what
I do not think that all disputes are about the rule of law, and this is where we need. Some people, what you said before about the judiciary or the judicial system wanting to offload the cases it has, and that's why we have mediation. Yes, I think whenever I've told people, especially here in Greece, that yes, I'm a mediator and it's very popular in the UK and it's gaining momentum here, and I explain it, and they said, oh, that's because the judiciary doesn't have time to handle. So it's a logical connection everyone makes that hears about this as a process. And I think that the means, what is it, the expression, the means justifies the end, or the opposite?
No, that's what it is. Means justify
we can reverse it. It can go both ways, but essentially this is why mediation has been promoted, yes, but it is helpful because mediation is a good process, whether it's formalized or not. We're not examining this, but it's a good process. And no matter how it's being promoted or for which reasons, the fact is that it's becoming more popular. And I think it's up to us to see if it is done in the way in which represents each of us as a mediator.
But before that, Georgina, what is important is that have I got you into a discussion, and am I putting you into a funny position? Please tell me.
I really enjoy this, and we could be talking for hours because I really have thought of all these in my personal time, and sometimes I've had the pleasure of discussing them with a few colleagues. But I think we can talk about all these layers of issues surrounding the court system and mediation. And when you said about the US, I posted an article on LinkedIn a few months ago about narcissism and litigation, where in the US everyone says, see you in court. And it's actually such a cool thing that we see all these series where everyone is taking each other to court as a showcasing how all powerful they are. And I think if we take the discussion further, it's what role models do we have in everything we see relating to law and justice? It is about imposing one's power on the other and not about finding solutions. So generally, I think it's about a cultural way of thinking that is adopted across different areas. And yeah.
Because I tell you why they're digging deeper. I'll tell you, because after digging deeper in the US, I will tell you about the court system and what's happening there, because everyone says that it's being discussed because of the court system. I'll tell you where it takes. But I'm just what you just said. This is what is on my website here. I'll see you in court may sound nice in movies. However,
Yes.
from my years of experience, this is okay. So this is how. But let me tell you about the court system and the US, because it's something that people say it's come through the court system. It's at least it's being discussed and maybe it's taking it forward. Again, Jeff Kitchabin is again a senior mediator in the US, and one of those rare people who's only a mediator, practices only as a mediator, which I want people to do. So he talks about his experience in the court system. They're kind of for free. So he had said, I'll be a mediator in the court. Concept being that being recognized, because lawyers are controlling mediation there, and being recognized by lawyers is something which people come into the court system. And that's why they give free mediation. So he was doing that, and then after quite some time, he said, "Why don't give me private work now?" So why should we give you private work? You've offered your services for free. So he just got disillusioned. He walked out, and this is what he again he was addressing the Beverly Hills Bar Association, where he spoke about this. That lots of people keep coming every time I come here. When I'm addressing people, all new faces come up. Because that's the concept, that people come in. It's a Ponzi scheme. People get trained. People come into the system, get disillusioned. They don't get work, go out. Another lot comes in. And this has been going on for 50 years. Their court system and mediation is 50 years. What has it resulted in? 100 million cases going into courts every year. What is the foundation that you've created? You say, okay, we are creating something that's happening. People are talking about mediation. They'll take to mediation. 100 million cases in a 300 million population cannot be handled by most countries. It can't be done. It won't happen. So overload. So release. Where do we release? Let's put it on to mediation. So you've just created through some system which is not working, and you keep telling people that this is your way out. That way out is also getting clogged. That's way out, because finally, look, you can say that we'll make mediators in 40-hour factories and you'll put a lot of people out. The process that they are going to get, whatever they are going to, it's not going to be a user experience that we would want, because finally you want a good user experience. So I'm saying the people who already are giving a good user experience all over the world in every like the community and everything, let's bring them out, because user experience seems to be the end aim of any training or certification, that we are doing this because user experience is good. When you can start with user experience, with people already there, take them forward. So that's why the mediation circles, the idea being this, that let's create that environment. Because debating the court system and the mediation in the court system, we'll fall into that trap. That, oh, this is what we need to talk about, and that's the only aspect of mediation which will get discussed. So I cut that off. I'm talking to you about it because this is the first time you're coming in, and I'm sure you have not watched all this, and I have to put this across. It's very important for me, because to take it in the right direction, we have to stop talking about these things, because the judiciary is not going to stop, because it's their vested interest. So this is how mediation is going to go out, and people are not going to be able to finally, look, you can call about justice and everything. Finally, it's about someone walking out happy from a process, feeling good about a process. Finally, any process works that way.
Yes, yes.
You walk into a restaurant, you want to walk out happy. Walk into a movie, you want to walk out happy. Every moment of your life, that's what you want to do. But when you're not walking out happy, and this is when that settlement concept that I'm saying, the gun on your head, that's the way people are going to experience it. So finally, it's not going to take off on a large level. Yes, in the court system, and connecting it to lawyers, damn good for you, you will do it there. But finally, again, we're doing disservice to those mediators who are not lawyers. And there's a large chunk of them out there which are doing it in families. Again, we'll connect it to the mother concept. The mothers are out there doing their whatever they're doing on an everyday basis. The connection with the children, the way it's connected. Look at the mediator and the.
That's true, but on this mother example, there are, well, as they say in psychoanalysis, there are mothers that are good enough and mothers that are not good enough. I mean, when we assess, these mothers are out there. It's a lovely thing because through parenting and all this, we do get human beings, and that's the whole point. But the assessment of what a mother should be for safe child development or not that safe child development, that, yes, somebody can come and say that there is good parenting and not good parenting. So I think it might be the same that, yes, it's also about assessing the methods used in mediation. Are they aligned with respecting the parties that come into mediation, or are they about serving, as you said, this court system, this process, this ticking the box, this I have like 1,000 settlements on my record, and this somehow shows my value as a mediator in terms of the methodology I'm using. So I don't know if you'd agree on that yes, it's a good analogy with the mother, but shouldn't we also question that everything has a good enough, not so good enough way of doing it, including parenting?
Yeah, no, absolutely. I'll tell you what the problem thing is, that everyone believes that their method of doing everything is the perfect one. I am the one who will be the one saying what is good parenting. Who am I to say what is good parenting? Finally, isn't it the child who has to say it? And if the child is not happy with their mother, I mean, let's find out how many of them are there. I mean, if it's a big problem happening there, all children are not happy with their mothers. Oh, there's a problem in the way parenting is happening. If a few people are not happy with their mothers, to say we're going to question the whole process of being a mother, and we will start certifications, and we will have accreditations, and we will have mock mothering. I mean, come off it, yeah. That's going to happen in a unique way. If we want humanity and society to develop, we'll have to have it happening in different ways. There are certain governments in this world who want things to happen only in their way. Yes, if you want to do that and make factories of people walking out with one thought process, damn good, do it. But that's not the way we want the world to develop, as one thought process. This is it. This is how it's done.
Yes, and you touch upon, sorry to interrupt you, but you touch upon a good point, that it's also about opening access to providers or accreditations, because I think this is where the limitation comes in. I don't think I'm very much in favor of training. Most of the things I'm aware of is because of sources online, of workshops, of my education, of books. So I'm very much in favor of that. But I think it came to me as a bit of a surprise, I think, both in the United Kingdom and in Greece, that certain things, again, with mediation are very locked into the system I know exists with law schools and the bachelor's degree, that only certain, you can only have these 4 modules, and if you change that and have another module, or if you don't do those core modules with this syllabus, then this won't allow this person to qualify as a lawyer. So this is part of a bigger discussion also about how creative we allow people to be with education and training.
Yeah,
and how we try and it has to do with how open our minds are about people that are also providing these services, because to some extent, even providers are not allowed to be more creative in the way in which they teach mediation, because again, it's very standardized, I think.
Georgina, I'm telling you, it's going to come down to the basic thing. Again, I'm going to colonization, that dispute resolution happens in courts and lawyers do it. That's the way the minds have been conditioned over hundreds of years. That's why that symposium that I had on indigenous peoples and mediation. There's a whole world out there which has gone about it in a certain way over centuries. And we want to believe what the colonizer told us, because that's what the colonizer put into your system through education, through everything, the structures that it created in society. That's the way they wanted it to happen. And keep that in their people's mind. Walking into a court, is that a realistic situation? Sitting with that wig out there, with that robe out there. We're living in very different times. I mean, we're not living in the colonizers' time. Let's move on to people. It's this freedom of people in whatever way. You create this atmosphere, sit on a pedestal. Is that natural? Is that the way you want people to believe, that we are there, you are there, we are the ones who decide whom you go to for dispute resolution? You have to come to this institution. We'll connect to mediation in some way or the other, because dispute resolution, you have no, you are not even connected to mediation. It's a different process altogether. I keep giving this example. In India, we have Ayurveda. I don't know whether there's a natural remedies, Ayurveda, and you have the what we call modern science, modern medical science. People who are trained in that modern medical science to say, now we will regulate Ayurveda. I mean, I think it's going to get more and more absurd as it goes on.
Yeah.
It's going to get absurd. I'm telling you, it's going to go if it goes in that direction. Look, I've caught you into this discussion
But
at
I
any point
would
of
like
day.
yes, I would just like to say that it's not about because we're talking about regulating and not regulated. It is also about who regulates, about the processes we elect and appoint. I think there are many things to be said about this, because I do believe that obviously we have to have, as a society, we have to have processes now, whether these are which parts we leave non-regulated and which regulated. That's a really big debate.
Again, I'm telling you,
I would, yes.
It'll come from the colonizer. It's going to keep coming from the colonization mindset.
I would like to ask you is, can you imagine a world without a judiciary at all?
Look, I'm telling you that you have to. That's why go into indigenous peoples and mediation. The whole concept, I'll give you the example. There was someone in that symposium from Nepal. Now, Nepal wasn't affected by colonization because the British in Nepal just wanted to be a protectorate. So they didn't have a role to play much in that country. So it developed in a certain way. So he's from a community there where he said everything happened by consensus. That community functioned by consensus. Who the leaders were going to be was by consensus. So functioning that way. Then as we grow, as time goes, politics now, current politics comes into play, creating divisions there, which is again the colonizers' concept, divide and rule. So division started, someone favoring this person to be a leader of that community, the other one favoring that. They created divisions in that community. They started creating that. So I'm saying that there is another side of interaction of people, which we've totally lost out on over hundreds of years. So that's why going to communities which have not been affected by it. Did they function without that? Look, leaders can be in every, let's not say indigenous peoples are only doing mediation or trying to build consensus. Part of that symposium was that let's also look at these people who are going to impose the solution on them. In indigenous communities also, there are people who impose solutions also, impose their decisions also. So it's not that it's this mediation, very nice, everything you're doing consensus. That's not the way. Even then, those communities happens all throughout the world. But I'm saying that is available to communities today. It's also something that can be developed. But on this end, dispute resolution happens in courts and lawyers do it. That mindset will never let that happen. And this is a process which has to develop organically within communities. First, you have to break them out of that mindset that that's a different process. The courts are there. Yes, if we want to go to them, they're available to us, but that's not our option. This is not connected with that. And just that word courts and mediation, and of course, free getting attached to it, has to be broken if we want to develop mediation. Otherwise, I have people, I mean, who come from say the US and talk about how they cannot practice as full-time mediators over the last 50 years. If you talk about mediation, they can't do it. So that's the way it's gone. And we think that, yes, we are moving in that direction. Yes, it's something that's going through the court system, but it will develop tomorrow on a broad base. It hasn't happened there. It hasn't happened in the UK for so many years. We call it a more mature market in relation to mediation. India has had it now since the last 17 years in the court system. I know where it is here. We can hear those discussions because I'm not connected to the court system at all, but I hear discussions of mediators in the court system and what is happening there. So it's not moving in that direction, but we can still have that colonized mindset that yes, the judiciary is taking it somewhere and they are the ones who control dispute resolution. So maybe they're taking us in the right direction. Maybe they're the Pied Pipers of Hamelin, and they're going to drop us down the cliff, but we are still going with them because that's the way we think, that's the way we have to go. But Georgina, look, I'm telling you, you've got into you started off into this discussion.
No, but I really appreciate the way you have got me thinking about thinking outside the box. And yes, you're right that sometimes we're conditioned into thinking that this is acceptable, but it might need to be broader. And while you were talking, I was thinking of something positive, which maybe can allow us to reflect on that as something positive, that to become a mediator, you do not need to be a lawyer. And I think this is very representative of the fact that mediation and being a lawyer is not to be found on the same let's say footing, or is not to be equated one to the other. And I think that's a very good thing. However, I won't say that I haven't found my education in law, because I do believe that law is very much linked to philosophy. And something funny I'd like to share is that when I was a teenager, I had actually wanted to study philosophy. And my parents looked at me, and they looked at each other, and they looked at me, and they said, no, you'll have to find something that's more practical. So I thought, what's closest to this? And they also had an idea of what would be closest to this, which is law. And I won't say I regret it, because law has a lot of ethics in it. So in that respect, but there's so many other sciences that can inform mediation. So, but I do think law is also one of those sciences. So I'm really happy that mediation is not limited to lawyers. Absolutely. But that it encompasses lawyers as well.
No, that's why I have so many people who are non-lawyers. That's the whole idea. There's so much more happening there. Yes. And there is a misconception somewhere that because there is some legal aspect involved in disputes, so lawyers should be the ones doing the process. And I have to keep clarifying this, that in that process, if there is a legal aspect, a law part of it that needs to be looked at for whatever reason, has to be looked at, you can bring a lawyer. If it's a project where there is a specialization of a civil engineer to come in, you can bring a civil engineer. People have misunderstood the process totally. They again are connecting it because of the court system. Just the fact that you use party, I've moved away from that. Somewhere you did use participants, and I was very happy because that's the way I'm putting it out. All this terminology that has come through the court system is affecting people's mind. Just to say that party part of it, you've already created this party and that party. And there was Ginny in that World Mediators Conference who brought this out. That there is if you look at that schedule, you'll find one on terminology and mediation. That participants. And of course, she says that people say opening statement. Where did that come from? The court system. She says in of course, she does community work, community mediation. She said we use orientation. We don't use that because look, how you start something off, the language that you start something off kind of sets the tone. What's coming to them. So we have to be very, very careful. I'm telling you, this is something which has to be looked at so carefully if you want to develop it. One is, we can flow with it. I'm a lawyer. I have because of that, of course I do commercial high value work. For me, perfect. It works perfectly for me. I can just put it out as this is mediation and it works for me. But that's not the idea. There's so much more that we need to do as as lawyers itself. We have a responsibility. It's a noble profession, at least it was supposed to be. So it was noble because of this reason, because you knew, maybe you studied the law part of it because the colonizer created that structure, but you were supposed to be the person who is going to bring that confidence or faith in the fact that there is a structure, yes, but you are going to in some way help them navigate that structure for their benefit. but you made them navigate the structure for your benefit. And you took it in that direction.
Yes,
So,
it's a fine line. It's definitely a fine line, and we should tread carefully. But the only thing I'd like to say is that, yes, having knowledge of, I won't say the law, but the rule of law and maybe the spirit, I think is quite handy.
no, I tell you, Georgina,
in the mindset we build around fairness.
this is,
of course, we won't judge fairness, but I think it just conditions us in the right direction. But
no, I've discussed this aspect. I discussed this aspect that if fair, reasonable, equitable people sit together, and whatever be their discussions and wherever it goes, that should be the law. If it's not the law, challenge the law. You don't need a lawyer to do it. That's what I'm trying to say. That's why I say the process doesn't require a lawyer, because what between you discuss is the way law should have developed. And finally, it'll should fit into the legal structure of your country. If if these are reasonable, fair, equitable, and all those words, nice words that you can use with it, if they're like that. So,
and again, Socrates is always asked, is it fair? Is it true? So we have all these questions about this unfolding virtue in a discussion. So, but I'm really grateful for our discussion, and you have prompted me to go and look at your videos on all these topics.
And you find me, if someone calls, even Andrew says, my rant, that's the way I do it. But that's the way it is. That's going to happen. So thank you very much. I mean, like I told you, I did push you into this discussion.
No,
and because of the fact that you wanted to be polite and you weren't going to say, I'm going to get out of it. So you stuck with it. And that's very nice of you. But we'll continue these discussions.
It was a pleasure. I enjoyed these philosophical debates, we could say.
A rant of mine, yes. Let's look at that. But closing session, 10 o'clock India time. Please drop in and let's just see what are the learnings and key takeaways from the symposium. We'll have a short discussion on that, and then Ken is closing his closing address. So I'll see you there. Thank you very much, Georgina. It was a pleasure speaking to you and debating with you.
Thank you very much.
See you. Bye. Bye.
Bye.